What's up? What's up? Damn thing won't let me update it. Shit. I guess I'm gonna have to let's see. I had just created some new layouts too. What's going on, everybody? All right, so as you see, turn this off. As you see in the title, and I was trying to actually make myself bigger, and that's just not going to work, I guess. Hey, so got a new motion that is filed. Oh, there it is. There it is. Okay. Now we're cooking with grease. So, welcome to the live stream. I figure this is the best place to go ahead and have some discussions about the latest I heard from my attorney and the federal case that's going on right now regarding the arrest, the Bunk arrest by the US Marshals outside of the federal courthouse in Lafayette, Louisiana. My attorney today filed a comprehensive motion to dismiss the Bill of Information on strong constitutional grounds. First of all, let me make sure. Let me check my comments. Hey, what's going on, Richard? What's up, Daisy May? Let me make sure my audio is correct. It needs to be on. Let's see. Okay. And there we go. All right. So I don't know if I guess I could start this off by just doing a reminder about what happened. That's probably actually the best thing to do is to do a quick showing of what happened. So let me share this screen right here. Share screen. Let's go to YouTube. All right. My channel. All right. Let's see. I think I sound muffled. Okay, hold on a second. Thanks for texting me. Tyrants beware. Let's see. All right, can you hear me better now? Text me and let me know, Tyrants beware, if you can hear me. You should be able to hear me a lot better now. All right. So, right here.
Imagine being able to build anything just by thinking about it. Meet Base 44, a complete AI creation platform.
Okay. So you're turning in live. Make sure my screen is correct. Okay. And he said turn up the volume just a tad bit. me see if I can go up on the on my sound anymore. No, it looks like that's going to be about as loud. I actually no, we'll go up a little bit less. All right, that's up all the way. All right, here we go. For National Fuck the US Marshals Day. This is We the People News. We're live outside the John M. Shaw United States Courthouse, where these tyrants with the US Marshals Service think that it's okay to criminalize journalism and the First Amendment. Had bolos put out. You ought to see, like, those that haven't seen the evidence, haven't seen the FOIA request. I knew that there was funny business going on. Y'all want me to come in? Hey, they're trying to wave me in the courthouse. So he just waved me in. Should I accept the invitation? I think I should accept the invitation. Hello. After you. Well, look who it is. Okay, you called me in here. You son of a bitch, I was outside on the fucking sidewalk. You told me to come in here, motherfucker. I'm going outside. You called me in here, motherfucker. You baited me in here, you piece of shit. Fucking pussy. You fucking pussy. Fuck your mom. He literally waved me in here. He told me to come inside, was grinning, and then told me he was going to throw me in handcuffs as soon as I walked in the doors. A public building. I'm holding my ground. I'm holding the line. Got to hold the line. And you're well within your rights. You cannot get pushed away. I mean, you give them an inch and they take a mile. Got to hold the line, folks. Got to hold the line. Huh? I'm on public fucking property. Let's go. Let's go. No, you're not. I'm getting it. You ain't gonna touch my camera. You ain't touching my camera. You ain't touching my camera. I'm getting my camera.
You grab the camera and you move it right now. If you don't, I am seizing this camera.
That's right.
That is absolutely right.
So what? So this door.
You've got 1 second.
This door is locked.
You've got 1 second.
This door is locked.
This is an entryway. We're on the other side of the barricade.
I'm right. I'm fine right here.
2,
I'm
1.
really. Oh! Ah! Ah! Oh! Ah! Good.
To the right, remain solid. Say again, you get the football. To the right, so I'm turning. Turn question.
I want an attorney. In 1971, the court drew a line in Cohen versus California. Paul Cohen's "fuck the draft jacket" wasn't polite, but it was speech. Justice Harlan's reminded, one man's vulgarity is another's lyric. It wasn't just clever phrasing. It was constitutional bedrock. The First Amendment protects the raw and the uncomfortable, because power doesn't get to dictate tone. 17 years later, NWA pushed that line further. Fuck the Police was banned from radio, condemned by politicians, and earned the group a warning letter from the FBI. But it survived. Not because gatekeepers approved, but because courts had already established in cases like Cohen that profanity and anger are protected when they are political speech. The music didn't just survive. It became an anthem against police abuse. Echoed what the court had acknowledged years before. Offensiveness is not a crime. Now in 2025, I found myself living that same fight in flesh and bone. My camera was my lyric, my audit, my anthem. Yet the U.S. Marshals tried to crush it with fists instead of bans. They treated journalism like contraband, seizing equipment as if reporting itself were illegal. They dragged me into cells.
Good now?
Beat me. Mocked me.
Check.
Tried to rewrite the law with violence. What they could not silence with statutes, they tried to silence with shackles. The irony is bitter. The FBI once threatened NWA for words. Today, federal agents brutalize citizens for cameras.
Atera is the IT painkiller. Remote monitoring and management, remote access, help desk and ticketing.
Tools of transparency. Both reveal the same truth. When speech exposes authority, authority will try to call it dangerous. Through FOIA, I had already uncovered evidence of U.S. Marshal Service bulletins and BOLOs targeting me, documents redacted so heavily you could barely read them, but enough to show they were treating journalism and First Amendment auditing as crimes. Those documents foreshadowed what came next. And now, because of what has happened, those pages must be unredacted. The conspiracy is no longer theoretical. It is lived proof. On August 25th, 2025, outside the federal courthouse in Lafayette, Louisiana, Marshal Hayden Newsom ordered me to move my camera away from a locked courthouse door. He threatened to seize it if I didn't comply. I complied. I backed up with my tripod and 4K camera in hand. That's when he attacked. He slammed me to the ground. My brand new gimbal was destroyed. My tripod shattered into pieces against me and underneath me. My 4K camera was wrecked. He violently accosted me as if press equipment was contraband. They dragged me into a holding cell. That's where Newsom drove his knuckles into my chest while I struggled to breathe. My heart was pounding, 140 to 160 beats a minute. When I knocked his arm away to stop the pain, he threatened me again and again. Assault on a federal officer. They laughed while I gasped for air. They delayed calling 911 for nearly an hour. When the paramedics finally arrived, they mocked me, saying I was just trying to delay jail. At the hospital, the indifference continued. Dismissive, condescending, unwilling to acknowledge the injuries inflicted by federal hands. When I was discharged late at night, Marshal Newsom shackled me and handed me off to Deputy Olivet of St. Martin Parish Jail. I asked before he even pulled out of the lot, "What am I being booked on?" Deputy Olivet admitted there was no charge, just a hold for the U.S. Marshals. I told him directly, transporting me without charge is kidnapping under 18 U.S. Code 1202. He claimed he was following orders. I reminded him of Nuremberg.
Our blue line.
Following orders is never a defense. He drove me anyway. At
Good night,
St.
brother.
Martin Parish Jail, the abuse escalated. Deputy Olivet and a female booking officer nearly broke my wrist, hoisting me by handcuffs ratcheted down so tight I could feel my bones grinding. It was torture, plain and simple. They threw me into a tiny freezing cell with only a torn blanket. I had no food the entire day. I lay on concrete in pain from my chest, my wrist, my ribs, mocked by guards who treated my suffering as entertainment. And all the while, the marshals laughed about what they had done, laughing at destroyed equipment, laughing at a broken body, laughing at constitutional rights discarded like trash. This is not law enforcement. This is not justice.
What's up, Joko?
This is a conspiracy. One already foreshadowed in the FOIA records. one that is now spilled into the open through violent arrest, torture, medical neglect, and unlawful detention. In 1971, the Supreme Court said the government cannot criminalize vulgar speech. In 2025, the US Marshal Service tried to erase that ruling with fists, with broken equipment, with shackles and cold cells. But here's the truth. They failed. I'm still here. I'm still speaking. And I will not stop. Because history will not absolve those who hide behind just following orders. It will remember those who stood. This is the warning. This is the record. And this is not the end.
So that's the recap right there on what happened. I was baited up there. I was engaged in a peaceful protest against the US Marshals because they put out bulletins. They put out bolos on me for being a journalist. I obtained this information through a FOIA request. It was absolutely atrocious what they did. So absolutely, I stand fully behind my decision to put what I put on signs. You know, we have the right to free speech. Free speech is good. Hate speech is evil. Absolutely. Okay? This was my freedom of speech to say fuck the U.S. Marshals for circulating bolos on me. That's absolutely uncalled for. They chose the absolute worst of pictures to do that. And the things that they said are, I mean, they should be ashamed of themselves, but they're not. They will be, because I'm going to hold them to account. So my attorney today filed a motion to dismiss on strong First Amendment grounds, and we're going to go over this motion. Because honestly, I haven't had the time to read through the whole thing myself. And so I'm going to do that with y'all. Y'all get to see it. It's filed. It's document number 16. United States of America versus Matthew Reardon. So, and I think what we'll do is, I get my laptop right here so I can see it better. I'm going to read through it, and what I'd like to do is, after I read through it, we're going to throw it into AI. We're going to see what AI has to say about it. We're going to check up on some of these citations, and this will be a learning session on what to do if you have any cases yourself. First of all is to read through and see what you got. Okay. So now into court, through the undersigned counsel, comes defendant Matthew Reardon, who respectfully moves this court pursuant to Rules of Criminal Procedure 12B3 to dismiss the bill of information filed against him. Mr. Reardon's motion is based on the grounds that the charged conduct constitutes protected expression under the First Amendment to the United States Constitution, that the prosecution seeks to punish his exercise of fundamental rights of free speech, press, and petition for redress of grievances. That 41 CFR 102.74.390 is facially overbroad and unconstitutional as applied to his peaceful journalistic and protest activities conducted in a traditional public forum. For the reasons set forth in the accompanying memorandum of support, let me just make sure that. All right, cool. So I guess the volume's good. I don't see anybody say anything about the volume. For the reasons set forth in the accompanying memorandum of support, this court should dismiss all charges as violative of clearly established constitutional principles. All right. So here's the memorandum in support. Now in the court, through the undersigned counsel, comes defendant, who respectfully moves this court pursuant to Rule 12b3 to dismiss the bill of information. Yada yada. Okay, same thing right there. Table of contents. You've got the background, the legal authorities, the argument. Okay, well put together. My attorney is Dustin Talbot, and he did a very good job. Look at the table of authorities right here, all the different cases that are cited in it. These, of course, we'll read over as we're reading through the complaint. All right, let me do this. That logo is over the top of what I've got to read. I got to take that off. This case presents fundamental questions about the scope of First Amendment protection for journalistic activity and political protests conducted at traditional public forums. The government seeks to criminally prosecute investigative journalist Matthew Reardon for peacefully documenting his grievances against federal law enforcement on the steps of a federal courthouse, conduct that falls within the heartland of constitutional protection under binding Supreme Court precedent. Mr. Reardon's prosecution arose after he discovered through a Freedom of Information Act request that US Marshals had placed him under surveillance for engaging in protected journalistic activities. In response to this perceived government overreach, he exercised his constitutional rights by conducting a peaceful protest on courthouse steps, expressing his grievances through both spoken commentary and written signs, while simultaneously documenting the event through live streaming and recording for his journalism platform, We the People News. Rather than address the legitimate constitutional concerns raised by his protest, the government responded by arresting Mr. Reardon, seizing his journalistic equipment, thereby transforming his exercise of fundamental rights into the predicate for criminal prosecution. The constitutional defects in this prosecution are multiple and dispositive. First, Mr. Reardon's conduct occurred in a traditional public forum entitled to the highest level of First Amendment protection, where the Supreme Court has consistently prohibited content-based restrictions on peaceful expression. Second, the government's enforcement demonstrates impermissible targeting based on the critical content of Mr. Reardon's message about federal law enforcement conduct. Third, the regulations' vague standards fail to provide constitutionally adequate notice of what conduct is prohibited when applied to protected speech activities. Fourth, the government's interpretation would criminalize core journalistic and protest activities without any showing of actual interference with legitimate government operations. Under controlling Supreme Court precedent, the prosecution cannot survive constitutional scrutiny and must be dismissed. Background: Mr. Reardon's constitutionally protected journalistic activities. Matthew Reardon operates We the People News, an investigative journalism platform that includes a website, blog, and YouTube channel with over 3,000 subscribers documenting events of public concern. On August 25th, 2025, Mr. Reardon And we'll skip over the footnotes. We'll come back to them maybe after this. I think they're important, but I don't want to sidetrack from the main read. Mr. Reardon engaged in core First Amendment activities on the front steps of the John M. Shaw Federal Courthouse, peacefully protesting government conduct, expressing grievances against U.S. Marshals, and documenting these activities through live streaming and recording. Mr. Reardon's protest addressed his documented concerns about government overreach. Through a FOIA request, he had learned that U.S. Marshals placed a BOLO, be on the lookout, alert, on him despite his engagement only in protected journalistic activities. His posters and spoken commentary criticized this surveillance and expressed his grievances against the U.S. Marshals Service and Department of Justice for what he perceived as unlawful targeting of his journalism. He was live streaming the protest using his iPhone and had a separate stationary dedicated camera attached to a tripod to capture higher quality video of the protest. The Marshal's invitation and Mr. Reardon's peaceful compliance. Mr. Reardon initially conducted his protest outside of the courthouse barricades on the sidewalk in front of the courthouse steps. After a few moments, U.S. Marshal Hayden Nugent summoned Mr. Reardon inside the courthouse. Mr. Reardon accepted that invitation, informing his live stream audience of the Marshal's request. After passing through the barricade, Mr. Reardon placed a stationary camera near one of the southernmost doors and attempted to enter, but found the door locked. He located an unlocked entrance toward the northern end of the building and entered the courthouse foyer. Inside, Marshal Nugent immediately threatened Mr. Reardon with arrest for recording inside of the courthouse, despite having just invited him into the building. Mr. Reardon expressed his frustration at being baited inside only to face arrest threats. He directed expletives at Marshal Nugent to express his displeasure with Marshal Nugent's actions, but he never threatened any physical harm and immediately receded from inside of the building. His reaction demonstrated his understanding of his rights and his willingness to avoid confrontation while expressing his displeasure with the contradictory treatment. After exiting the courthouse, Mr. Reardon continued his peaceful protest activities, interacting cordially with all members of the public and never attempting to re-enter the building. At one point, Mr. Reardon holds one of his posters near the window so that the marshals inside can read the poster, and holds his phone with the live stream up to the window. Instead of continuing to stand and hold his cell phone with the live stream near the window, Mr. Reardon moves his dedicated camera on the tripod and places it near one of the southernmost locked doors to the courthouse, filming in the direction of the window. These two moments are captured in the following photographs provided in Discovery. So these they turned over in Discovery. You can see that my camera is right there. This door has never been unlocked. It's always been locked from the inside and the outside. This is confirmed by my attorney. The door is, you cannot pass through the door, and I knew that. That's why I put that right there. It's not blocking anything. Mr. Reardon then goes back out to the courthouse steps, resumes his protest, and interacts with his live stream followers. At one point, an exterior court security officer approaches and records Mr. Reardon on what appears to be that officer's cell phone. That same officer later tells Mr. Reardon that he is trespassing by standing on the front steps of the courthouse. Mr. Reardon is arrested despite complying with the marshal's demands. More than 20 minutes after placing his camera near the locked door, Marshal Nugent emerged and demanded removal of the camera and threatened to seize the camera. When Mr. Reardon pointed out that the door was locked, and therefore not obstructed, Marshal Nugent ordered him to move the camera beyond the barricade. The inside of the doors in question contains a sign that directs visitors of the courthouse not to exit that door, that it is an emergency exit only. Mr. Reardon immediately complied, grabbing his camera and tripod and backing away from the building. After moving the equipment to a position where neither he nor the camera could obstruct the door, he stated, "I'm fine right here." At this point, despite Mr. Reardon's full compliance with the marshal's demands, Marshal Nugent forcibly seized the camera and tripod, causing Mr. Reardon to fall and drop his phone. Marshal Nugent then arrested Mr. Reardon and seized both his camera and cellular telephone, which contained materials related to his journalistic work. And if you look at the video, he's telling me to back up, and I'm backing up. I'm moving backwards. And then he starts the fast 3, 2, 1 countdown as I'm moving backwards. He had it in his mind from the very beginning that he wanted to be as violent as possible and violently arrest me. I can't wait to show off my gear that got seized. What's left of it, it's completely destroyed. When he broke the tripod over me, you can see him swinging as he grabs it, breaks the tripod, the leg goes flying. Like it's completely destroyed. I don't know. I know the 4K camera's destroyed. I know that was on the ground. They got the memory card out of that, but on August 26, 2025, Mr. Reardon was charged with a petty offense via bill of information containing 1 count of loitering, exhibiting disorderly conduct, or exhibiting other conduct on federal property in violation of 41 CFR 102.74.390. The bill of information alleges that Mr. Reardon did knowingly and intentionally create loud or unusual noise or a nuisance and or unreasonably obstructed the usual use of entrances, foyers, lobbies, corridors in or on federal property. This is a completely unconstitutional statute. I can't believe that they even have this statute. My attorney said he's never seen it used, and God willing, this goes to trial and doesn't get tossed out. I'm thoroughly looking forward to having this statute struck as unconstitutional. I'm thoroughly looking forward to setting case law on this matter, okay? Because, let's look at that again, okay? 1 count of loitering, exhibiting disorderly conduct, or exhibiting other conduct on federal property, okay? Other conduct, very vague, okay? Intentionally creates loud or unusual noise. The First Amendment protects unusual noise. You could easily say, okay? The way that they're structuring this is basically it's completely counteractive to the First Amendment. That can be read any number of ways, and that's already long been addressed in firm Supreme Court precedent. The legal authorities, free speech, and the right to assemble and petition the government are an essential part of both the Louisiana and the United States constitutions. The First Amendment provides Congress shall make no law representing an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Louisiana Constitution provides in Section 7, no law shall curtail or restrain the freedom of speech or of the press. Every person may speak, write, and publish his sentiments on any subject, but is responsible for abuse of that freedom. Section 9, no law shall impair the right of any person to assemble peaceably or to petition the government for redress of grievances. Title 41 of the Code of Federal Regulations, Section 102.74.390 is titled, What is the policy concerning disturbances? And provides in relevant part, all persons entering in or on federal property are prohibited from loitering, exhibiting disorderly conduct, or exhibiting other conduct on property that creates loud or unusual noise or a nuisance, unreasonably obstructs the usual use of entrances, foyers, lobbies, corridors, offices, elevators, stairways, parking lots. So, federal property, not just the courthouse, okay? So we have basically a land grab with the federal courthouse, and you can actually, there's a more recent video posted by Brandon Duplicient where John Ferris, the supervisory US Marshal, basically keeps backing him up. He's far back, way back from where I was, and saying that you can't have a phone on federal property. This is tyranny at its finest, folks. And these rules, these local rules that are passed by the judges at this courthouse, are undeniably unconstitutional and in violation of the First Amendment and Section 7 and 9 of the Louisiana Constitution. This is what this is going to show. You got to look at Part B right there, okay? Unreasonably obstructs the usual use, okay? The usual use. Key word. Usual. Okay? On a door, when there's 8 doors across the front, they have no, really that was the only clear glass, that I could put it in. The rest is like stone siding or whatever. So I took a door that's not in use, has never been used for entry or exit, and I was right there by it. So I think that, I know that the United States of America, should they choose to proceed on this, is going to have an awful hard time proving their burden right there. That I unreasonably obstructed the usual use of an entrance, because a locked door from both sides is not a usual entrance. And unreasonably, I was perfectly fine down by the road on the sidewalk where I was at until those jackasses motioned for me to come up there. Had they not have done that, I would have stayed down there by the road where I was at. So, upon being baited up there, which I think falls under entrapment, and seeing that they're inside laughing it up and recording me outside on their phones, I wanted to record them. I have a right to observe what public officials do on public property. So, the one easy way to make sure that I don't miss a thing and one up them, because they've got, I won't say it's one up them from the standpoint of them recording me on their phones inside, but they've got cameras in and around the courthouse. Okay? I had one camera up there against the glass. The argument: this prosecution violates clearly established Supreme Court precedent protecting political protest in traditional public forums. Edwards v. South Carolina and United States v. Hilton mandate dismissal of this charge. Mr. Reardon's prosecution is constitutionally impermissible under binding Supreme Court precedent. In Edwards v. South Carolina, African-American protesters marched to the South Carolina State House grounds to submit a protest to the citizens of South Carolina, along with the legislature bodies of South Carolina. Our feelings and our dissatisfaction with the present condition of discriminatory actions. When police ordered the protesters to disperse, they refused and engaged in boisterous, loud, and flamboyant conduct. The protesters were arrested and later convicted of breach of peace. The Supreme Court reversed the protesters' convictions as a violation of the First Amendment, incorporated against South Carolina via the 14th Amendment, even though the protesters reacted to law enforcement by becoming loud and unruly. The court noted that not until they were told by police officials that they must disperse on pain of arrest did they do more. The court found unconstitutional protection even when the protesters engaged in additional expressive conduct after being ordered to leave. Mr. Reardon's conduct presents an even stronger case for constitutional protection. Like the Edwards protesters, Mr. Reardon was protesting in a traditional public forum to express his feelings and his dissatisfaction with what he perceived as discriminatory actions by the US Marshals, specifically the bolo alert placed on him despite engaging only in protected journalistic activities. Critically, Mr. Reardon maintained peaceful conduct even when Marshal Nugent created the precise confrontational dynamic of the Edwards Court recognized as protected. When invited inside only to face immediate arrest, Mr. Reardon expressed frustration through profanity, but immediately receded from the building without physical confrontation. When later ordered to move his camera, he immediately complied, demonstrating restraint that exceeds even the Edwards protesters. The Fifth Circuit's decision and United States v. Hilton likewise mandates dismissal of this case. In Houghton, the defendant filed criminal complaints against IRS agents who had unlawfully entered her property, and the government subsequently indicted her for obstruction of justice based on her complaints against the agents. The Fifth Circuit affirmed the district court's acquittal, holding that criminal sanctions could not be imposed for the defendant's legitimate and protected exercise of her right to petition for redress of grievances. The court in Houghton emphasized that the defendant genuinely attempted to protect her rights through the orderly pursuit of justice, and concluded that we likewise cannot condone the imposition of criminal sanctions for Hilton's exercise of her constitutional right. Mr. Reardon's situation presents an even stronger case for constitutional protection. His FOIA request revealing the Bolo alert and his attempts to file an official complaint in person against the US Marshals at the Lafayette Courthouse demonstrate his orderly pursuit of justice through official channels. His peaceful protest and journalistic documentation represent the traditional means of seeking redress. The government's prosecution of this protected activity constitutes precisely the type of indirect restraint on fundamental constitutional rights that the First Amendment prohibits. Courthouse steps constitute a traditional public forum entitled to the highest level of First Amendment protection. Mr. Reardon's activities occurred on courthouse steps, which constitute a traditional public forum entitled to the highest levels of First Amendment protection. In United States v. Grace, the Supreme Court established that the public sidewalks forming the perimeter of the Supreme Court grounds, in our view, are public forums and should be treated as such for First Amendment purposes. The court emphasized that traditional public forum property occupies a special position in terms of First Amendment protection and will not lose its historically recognized character for the reason that it abuts government property that has been dedicated to a use other than as a forum for public expression. The Supreme Court has long recognized that the right to peacefully assemble existed long before the adoption of the Constitution of the United States. Derives its source from those laws whose authority is acknowledged by civilized man throughout the world. The court explained that the right of the people to peaceably assemble for the purpose of petitioning Congress for redress of grievances or for anything else connected with the powers or the duties of the national government is an attribute of national citizenship, and as such, under the protection of and is guaranteed by the United States. Mr. Reardon's conduct involves three forms of constitutionally protected expression. Mr. Reardon's conduct involves three forms of constitutionally protected expression requiring the Bill of Information to be dismissed, even if his conduct would otherwise violate 41 CFR 102-774-390. See Brown v. State of Louisiana. Reversing the breach of peace convictions on African American protesters, holding that even if the protesters' conduct were in the scope of the breach of peace statute, it would be required to assess the constitutional impact of its application. And we would have to hold that the statute cannot constitutionally be applied to punish petitioners' actions in the circumstances of this case. First, Mr. Reardon's protest activities constitute core political speech criticizing government officials and their conduct. His posters documented his grievances against the US Marshal Service and Department of Justice for what he perceived as unlawful surveillance through the Bolo alert placed on him despite engaging only in protected journalistic activities. Such criticism is at the very center of the constitutionally protected area of free expression. New York Times v. Sullivan, that's a good case. Second, his journalistic documentation through recording and live streaming on We the People News represents protected press activity. The Supreme Court has recognized that news gathering is entitled to First Amendment protection. Brandsburg versus Haynes, that's another good one. Acknowledging that news gathering activities merit First Amendment protection and that without some protection for seeking out the news, freedom of the press could be eviscerated. Recording government officials constitutes core First Amendment activity. Glick versus Cuniff, another great one. It's always used. Gathering information. All government officials gathering information about government officials in a form that can readily be disseminated to others serves as a cardinal First Amendment interest in protecting and promoting the free discussion of government affairs. The First Circuit specifically recognized that modern technology has eliminated meaningful distractions between traditional journalists and citizens documenting events of public concern, noting that changes in technology and society, brighten my screen a little bit, have made the lines between private citizens and journalists exceedingly difficult to draw, given that many of our images and current events come from bystanders with a ready cell phone or digital camera rather than a traditional film crew. Mr. Reardon's use of both handheld and stationary cameras to document his protest for his 3,000 subscriber YouTube channel demonstrates precisely, and it was on several channels. It was on Patriot News Activism, it was on Facebook, it was on LinkedIn. This intersection of modern journalism and traditional activities that the First Amendment protects. Third, his expression of grievances against government officials and request for accountability constitutes petitioning government for redress, which is among the most precious of the liberties safeguarded by the Bill of Rights. Mr. Reardon's protest specifically addressed his documented concerns about government overreach, including the Bolo alert he discovered through his FOIA request. Offensive language does not remove First Amendment protections. What do you want to bet? That this paragraph right here says something about Cohen versus California. I didn't look at the table of authorities close enough. I bet you that Cohen versus California is in here, though. That the content of Mr. Reardon's speech, both his spoken words and the language on his posters, might be viewed by some as containing coarse or offensive language, does not remove its protection under the First Amendment. Speech is often provocative and challenging. Indeed, speech may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or stirs people's anger, because the speech may strike at prejudices and preconceptions and have profound unsettling effects as it presses for acceptance of an idea. Let's see. No, so I didn't see anything about Cohen in there. I'm surprised. Cohen versus California, when Paul Cohen wore a jacket into the federal courthouse in 1971 out in California with the phrase, "fuck the draft." I think that would have been, maybe it's just because it's so well known. I personally would definitely side Cohen right there. But the prosecution constitutes content-based discrimination requiring strict scrutiny. Section 102, 74-390 fails strict scrutiny when applied to suppress criticism of government officials. The government's selective enforcement demonstrates impermissible content-based targeting. Mr. Reardon was subject to BOLO surveillance specifically because of his journalism critical of federal law enforcement. When he protested this surveillance, he was arrested for conduct that would be ignored if directed at any target other than federal officers. The allegedly offensive nature of Mr. Reardon's language constitutional protection. In Brown v. Louisiana, the court held that even when protesters' conduct might fall within the technical scope of the statute, courts must assess the constitutional impact of its application and cannot allow prosecution to punish protected expression. The government cannot transform protected political speech into criminal conduct by characterizing criticism of federal officers as disorderly conduct. Content-based restrictions in traditional public forums are subject to strict scrutiny and can be sustained only if they are necessary to serve a compelling state interest, and that is narrowly drawn to achieve that end. The government cannot meet this demanding standard when prosecuting peaceful journalistic documentation on courthouse steps. The loud or unusual noise or nuisance provision violates the First Amendment as applied to Mr. Reardon's protected speech. The Fifth Circuit has never addressed the constitutionality of the statute, and no circuit has addressed the application of 102-74-390 to peaceful journalistic documentation and protect political protest on courthouse steps. So this is the first case. This case sets a precedent. Which constitute a traditional public forum entitled to the highest level of First Amendment protection. Mr. Reardon's vocal expression constitutes protected political speech. The government cannot prosecute Mr. Reardon under this statute for creating loud or unusual noise or nuisance when his vocal expressions consisted entirely of protected political speech, criticizing government officials. Mr. Reardon's spoken commentary during his protest addressed his grievances against the US Marshal Service, documented through his FOIA-obtained evidence of the BOLO alerts placed on him for engaging in journalistic activity. The government cannot regulate protected political speech based on its volume or allegedly offensive conduct or content when that speech occurs in a traditional public forum. In Edwards, the court protected protesters who engaged in boisterous, loud, and flamboyant conduct while expressing political grievances. Mr. Reardon's actions in this case are thus constitutionally protected against censorship or punishment, unless shown likely to produce a clear present danger of a serious, substantive evil that rises far above public inconvenience, annoyance, or unrest. Unconstitutional content-based discrimination and enforcement. The government's application of the noise provision demonstrates impermissible content-based discrimination. Mr. Reardon's prosecution stems not from any genuinely disruptive volume level. He was outside of the courthouse when arrested, but from the content of his criticism of government officials. The BOLO alert placed on Mr. Reardon despite his engagement only in protected journalistic activities demonstrate content-based targeting. This protest specifically addressed the surveillance, expressing grievances about what he perceived as retaliation against his journalism. The Supreme Court has recognized that selective enforcement or even a content-neutral law may violate the First Amendment. Here, the undersigned has no indication that the government has ever prosecuted other individuals under Section 102-74-390 for being loud or boisterous outside of the Lafayette Courthouse, despite yearly events such as Mardi Gras parades and Festival International Day, whatever, Louisiana, occurring at the same location. Mr. Reardon was protesting. Mr. Reardon's arrest under 102-74-390 is impermissible content-based enforcement of the regulation. Unconstitutional vagueness of the noise provision. The loud or unusual noise or nuisance standard provides no meaningful guidance about what conduct is prohibited. See, I said this earlier about the unusual. A person of ordinary intelligence cannot determine what volume, level, or type of expression crosses the line from protected speech to criminal conduct. The regulation's failure to provide objective standards for enforcement creates the arbitrary application that the vagueness doctrine prevents. Here, the vagueness of loud or unusual noise or nuisance may authorize and even arbitrary and discriminatory enforcement. By failing to establish minimum guidelines to prevent a standardless sweep, this vagueness is compounded by the complete absence of any evidence that Mr. Reardon's vocal expressions actually disrupted courthouse operations or interfered with any legitimate governmental interest. The record shows that members of the public continued to enter and exit the courthouse during his protest without incident, demonstrating that any alleged nuisance was merely the government's disagreement with his message, rather than any actual interference with courthouse functions. The unreasonably obstructs the usual use of entrances provision is unconstitutional as applied to Mr. Reardon's camera placement. No actual obstruction occurred. The government cannot sustain a prosecution under this statute for unreasonably obstructing the usual use of entrances when no obstruction occurred. He placed his camera near a door that was locked and always remains locked to the public. As he noted to Marshal Nugent, no actual obstruction occurred or could occur when the door is inaccessible to the public. The record demonstrates that during Mr. Reardon's protest, other members of the public entered and exited the courthouse through the operational northern entrance without any interference from his activities. The regulations text requires that conduct unreasonably obstruct the usual use of entrances. When a door is permanently locked to public access, there is no usual use. An emergency exit is, by its very nature, not an usual use, and Mr. Reardon's camera was certainly not unreasonably obstructing the emergency exit, as it could easily be stepped around or pushed aside in a true emergency. The government's interpretation was any expressive activity near any courthouse entrance, regardless of whether that entrance is actually accessible or whether any person actually impeded. Camera placement has protected news gathering activity. Mr. Reardon's camera placement constitutes protected news gathering activity, entitled to First Amendment protection. The positioning of recording equipment to document newsworthy events represents core journalistic activity that cannot be criminalized absent compelling justification, narrowly tailored to achieve legitimate governmental ends. The government's demand for camera removal, despite no occurring, demonstrates that the restriction aimed at suppressing documentation of political speech rather than addressing any legitimate regulatory concern. Overbreadth of the obstruction provision as applied. When applied to Mr. Reardon's peaceful camera placement near a locked door, the regulation sweeps too broadly, capturing protected journalistic activity alongside any legitimately legal conduct. The overbreadth doctrine is designed to prevent the chilling of protected expression. A regulation that covers substantially more speech than the First Amendment allows is overbroad and thus invalid. The regulation's prohibition on conduct that unreasonably obstructs the usual use of entrances includes within its scope activities protected by the First Amendment when applied to news gathering equipment placed in locations where no obstruction occurs. The regulation is overbroad as applied to Mr. Reardon's actions. In this case, compliance demonstrates absence of intent to obstruct. Mr. Reardon's immediate compliance with Marshal Nugent's demand demonstrates the absence of any intent to obstruct courthouse operations. When Marshal Nugent moved with the camera, Mr. Reardon grabbed his camera and tripod, backed away from the building. This full compliance occurred before any arrest and demonstrates that Mr. Reardon sought to engage in protected expression while respecting legitimate regulatory concerns. The government's prosecution, despite this immediate compliance, reveals that the charges target the content of Mr. Reardon's expression rather than any genuine concern about obstruction. Under these circumstances, the regulation as applied violates both the overbreadth and vagueness doctrine by criminalizing protected expressive conduct without providing adequate notice of what activities are prohibited. In conclusion, Mr. Reardon's conduct falls squarely within the Supreme Court's protection of the traditional public forum. His immediate compliance with law enforcement directives, peaceful interaction with the public, and legitimate journalistic purpose distinguish this case from any legitimate application of Section 102, 74, 390. The government's prosecution violates clearly established First Amendment precedent and cannot survive constitutional scrutiny. The regulation's application to Mr. Reardon's conduct fails every constitutional test. It restricts protected expression in a traditional public forum, discriminates based on the content of his criticism, lacks narrow tailoring to serve legitimate governmental interest, and provides inadequate notice of prohibited conduct. Wherefore, defendant Matthew Reardon respectfully requests this court grant his motion to dismiss the bill of information and dismiss all charges against him. Hell yeah. He did that. He did that. I'm the only thing I'll say in all of that is I'm surprised that Cohen versus California is not mentioned, but I don't think it needs to. I mean, I think he hit the nail on the head with that. I'm thoroughly looking forward to any response by the U.S. Attorney's Office on this. I would love to see what type of response they come up with. So, as I said at the beginning of this, I'm going to, so what I have here, I always used Chat GPT and Claude. It had to be a combination. Okay. Well, I had some direct training from an attorney up in the New York, New Jersey area, and um, so what I've done is I've taken this PDF right here, and I've thrown it into oh, hold on a second. I don't think I even have this tab up. I don't have this tab up. Glad I caught that before I just started going, because I would have gotten to the end, and then I would have seen all the messages saying you didn't have it up on the screen, and other than that, Claude is a phenomenal AI. It's great for legal stuff. I like to refer to Claude as the attorney. ChatGPT is a great paralegal. Claude is the attorney. Okay, and so basically, what we're going to do here is, I don't have the other documents. So I was, let's say, evaluate this motion for strength and any weaknesses. Provide any possible responses by the prosecution their chances of success and the chance of for this motion to dismiss. Also, check all the cited cases and provide any additional case law as it applies to this case. Okay, so I've got right here style, lawyer, judicial precision. I made this style right here. Basically put in for it to basically act like an attorney. Got extended thinking on, and we'll stick with this model right here. Okay, and let's send this through and see what it gives us. Challenging motions, vagueness, and potential content-based discrimination. Hey, what's up, Slideshot? I'm just now looking at the comments. I couldn't look at them when I was reading over everything. Um, all right. So here we have it. Constitutional analysis. Motion to dismiss in United States versus Reardon. It's a paradigmatic First Amendment challenge involving the intersection of political protest, press freedoms, and petition for redress of grievances in a traditional public forum. The legal framework and factual foundation demonstrate substantial constitutional merit, though certain vulnerabilities require careful examination. Robust doctrinal foundation. The motion correctly identifies the courthouse steps as traditional public forum entitled to the highest level of First Amendment protection. This classification triggers strict scrutiny for content-based restrictions and requires narrow tailoring for time, place, manner, or regulations. The citation to Edwards v. South Carolina provides directly applicable precedent protecting political protesters who become boisterous, loud, and flamboyant when confronted by law enforcement. The analysis of protected expression, political speech, press activity, and petition for redress creates multiple constitutional bulwarks. Yada yada. So, the factual narrative demonstrates classic protected activity, peaceful protests addressing documented government overreach through BOLO surveillance, immediate compliance with law enforcement directives absent of actual obstruction, and legitimate journalistic purpose through an established platform with substantial viewership. Wouldn't go so far as to say that. Substantial viewership, highly shadow banned. The defendant's cooperation and de-escalation efforts distinguish this case from scenarios involving genuine disruption and confrontation. All right. So let's look at the potential weaknesses. The government will likely characterize 41 CFR 102.74.390 as a content-neutral time, place, and manner restriction, serving compelling governmental interests in courthouse security and operations. The regulation's facial neutrality regarding speech content could support intermediate scrutiny analysis under Ward versus Rock versus Racism. Counter-analysis. Selective enforcement pattern, BOLO surveillance specifically targeting defendants' critical journalism, followed by arrest for identical conduct that would be ignored if directed elsewhere, demonstrates content-based application requiring strict scrutiny. Under Reed versus Town and Gilbert. Federal property distinctions. The government may distinguish foreign doctrine by emphasizing federal courthouse security requirements that justify greater restrictions than typical public spaces. The invitation inside, followed by recording prohibition, could be characterized as reasonable accommodation within security constraints. The counter-analysis, US versus Grace, specifically rejected the argument that traditional public forum status changes when property abuts government property that has been dedicated to a use other than public expression. The courthouse steps retain their traditional public forum character, regardless of adjacent federal facilities. Disruption and safety concerns. The profanity in defendant's signs and verbal expressions, combined with camera placement near an emergency exit, provides the government's strongest argument for actual disruption or safety concerns justifying the arrest. Counter-analysis. So the Supreme Court precedent consistently protects offensive political speech. Texas versus Johnson, Snyder versus Phelps. The emergency exit remained unobstructed, and immediate compliance demonstrates absence of genuine safety concerns. The motion would benefit from citing McCullen versus Coakley, Buffer zones restricting speech on public sidewalks must be narrowly tailored, serve significant governmental interests. Matson versus Women's Health Center, Frisbee versus Schultz, Turner versus Driver, Philip Turner. That's the Batuzzi on YouTube. Fifth Circuit recognition of First Amendment's right to record police in public. The government faces significant constitutional hurdles. Content-based enforcement in traditional public forum requires compelling interest narrowly tailored. Yada yada. All right, vagueness doctrine. Factual deficiency. Government success of likelihood. Look, what about that 99% success rate, win rate? This thing evaluates it, and I would say that's at a max. That's generous at 20 to 25%. The path involves characterizing the regulation as a reasonable time, place, and manner restriction, emphasizing courthouse security concerns. However, the complete absence of actual interference with legitimate governmental operations and the immediate compliance pattern severely undermines these articles or these arguments. Motion success assessment, likelihood of success, 80 to 85%. This motion should prevail based on controlling precedent, traditional public forum status, protected activity nexus, absent of compelling justification, immediate compliance. The motion represents a strong constitutional challenge to prosecutorial overreach, targeting protected political expression, the convergence of traditional public forum doctrine, robust First Amendment precedent, and favorable factual circumstances creates multiple paths to dismissal. While the government retains theoretical arguments regarding federal property security, the factual records demonstration of peaceful, compliant conduct renders such arguments constitutionally insufficient under controlling Supreme Court precedent. That's what we have for you folks. Glad I got to this. I'm going to, as part of this live stream, roll over to this brand new podcast called The Rico Tapes. Man, it is this first episode. It's a shocker, okay? An absolute shocker. I just built an app for it. I just coded an app. I'm waiting on the domain name to actually sync up so I can give you the good domain to go to. It might be working now. I don't know. I know if you go to ricotapes.online, that's supposed to be the web address that's linking to it. It said it could take up to 24 hours to link. I don't think it's going to take that long. But this is a perfect link, actually. A little on the long side. I end this live stream now. But I'm going to also go back live so that it triggers a new live stream and throws it fresh into the live stream feed and the shorts feed. Sends out a fresh notification. I'm going to do that right now. I'm going to end this. I'm going to set up the next one, and I want you to listen to that first episode. All right? So make sure you hit that subscribe button. Be watching the channel because it's going to go live, and within the next 3 to 5 minutes after this one ends, right here, I'm going to, yeah. So I'm going to go ahead and I'm going to end this now, and I'm going to set up this. Enjoy the music while I'm setting up this next live stream, and listen to. You'll be hooked on this podcast. I hope so, at least. All right, y'all. Thanks for tuning in.
That love falls apart, a little piece of heaven. said, quiet, just play your part. But I lost it all trying to listen to my heart. Friends fell off when the fire got real. Family vanished when the wounds wouldn't heal. Lydia's face in my mind through the dark. Her laugh echo loud, it's my spark in the arc. Marriage gone like a whispering wind. While I stood for the truth, they ain't want me to defend. Felt betrayal from the ones I fed. Same ones now praying, I wound up dead. Courtroom lies, I ain't for to retreat. Even caged in the system, I refuse defeat. Took every loss, still sharpen my aim. They laugh when I cried, now remember my name. Gave up peace, gave up love, gave up art, but I never gave up. I listened to my heart. They took my freedom, took my name, tore my life apart, but I still stood tall. I just listened to my heart. Lost love, lost friends, left me out in the dark, but I never lost soul. I just listened to my heart. They can't kill truth, can't change what's real, can't stop this voice or the way I feel. So through the pain, the war, the cold, the start, I walk this road alone, still listening to my heart. Every tear I shed became a weapon in my chest. Every sleepless night just put my will to the test. I ain't just fighting charges, I'm fighting for my name, for my kids to know they daddy never bowed to shame. They took my time, my home, my spark, but couldn't dim the fire burning deep in my heart. Let them judge, let them lie, tear my story apart, but I still breathe truth, I still listen to my heart. I remember cold nights, Galveston steel, 11 months lost, scars that won't heal. Called insane while they plotted and schemed, but I saw the whole play from behind the screen. Didn't flinch when they brought on the heat, didn't break when the devil tried taking my seat. Didn't fold when the system played dirty, told them I was built for the war, they ain't worthy. Madeline gone, yeah, the silence hit hard, like echoes of laughter, trapped in the yard. Friends dipped quick, love turned to ash, still I rose from the smoke with a rebel stash. I lost years they could never give back, now I'm climbing out the wreck with the truth on my back. Pulled me down, but I stood from the start, and I die on this hill, I still listen to my heart.